Well, I mean, we just kind of threw you into the fire.
That's okay. I read up on things. It's like being in law school again.
Yeah.
You just read up on some stuff. and start talking.
I actually had to do citations. I had to read
Grading
cases.
and tree
I
removal?
was like, whoo, I could do this.
It's like it's a tree thing.
Is this grading and tree removal?
9826 was a grading, and then 31.
Okay.
Okay.
They're both site modifications,
They're both
period.
site
but-
modifications.
But
The
specifically
nature
to
of the
you and me.
The nature of the modification.
Okay.
May I ask you to move down one seat so I can see you? Well, but I guess it's more important that he sees you.
He stands up to
I was
talk.
gonna stand up there. I have to
He stands
stand
up to
up.
talk.
No, we're not sure where this is gonna go.
Okay. I love
Those are
coming
the
in and
best-
having
yeah,
the
those are the
wiggy
best
ones.
time.
Yeah. It's kind of our whole job.
Yeah, but you're making it sound like it's gonna be more interesting than it's gonna be.
And we all have a time, we all have meetings at 9
I
o'clock.
saw that.
All I know is I just wanna be like Eric when I grow up.
We want to be
Why?
Eric.
Tall?
Well, tall, okay, let's go tall, thin, but no, calm. His calm demeanor.
You're pretty calm. Well,
Thank
when
you.
I see you,
Thank you.
I've never seen you not calm.
Facial expressions.
I've seen everybody in this room not calm at one time or another.
I have an Amazon Echo in my kitchen, and I tell it to play Bob Marley whenever I get stressed. And I'm good after 3 little
Then you're
bars.
happy?
Yeah,
Is that how it goes?
yeah.
That's all it takes, huh?
I might have to try that.
You're gonna come over to our office, you have Bob Marley playing on the entire office.
You can't be
BTS
upset.
works really well, just
Yeah,
saying.
you can't be
What
upset with
does?
Bob Marley playing.
BTS, Korean.
Joanne, I'm sorry to admit this to you, but I'm gonna do it publicly. I don't think I've ever listened to BTS.
You actually have, if you listen to the radio, you just dip and known it.
Okay, all
Be
right.
honest, they're always played. They're
Oh,
top
okay.
40.
Oh, only on certain channels.
Top 40.
Asian boy band, I think.
If you've listened to top 40 at all, you've listened to something.
Have I really?
Yeah.
I'm gonna
So my
purposely,
niece loves them.
listen.
Like she's been to I think she went to Texas to see them in concert. And I think she went to Atlanta to see them
I
in
went to,
concert.
they didn't ever come to Orlando, that would be nice. I saw them in Vegas.
Okay, I know it was K-pop. It might not have been BTS.
Right, there's a lot of groups.
She was like singing every single word, and her dad was like, "They're barking, and like the whole audience is barking. It's so weird." No, it's K-pop.
It's amazing. Billion-dollar industry.
Yeah. She's like, I don't know.
Hi, Denise Lynn. Denise Lynn, I'm the county attorney. It's nice to meet you.
I already got tickets. I came when saw them in Orlando. I don't know, but I went and saw them 10 years ago.
I wanna put a bubble around. That's what I saw, not 10 years.
Yeah,
It was on my bucket list of bands.
yeah, they're coming back.
No, they don't need the money, so why are they doing it? They can't stop.
I had a good conversation with Dale yesterday.
Oh yeah.
Well, he got a new case from us.
The 7051.
Aren't you happy? You should be doing cartwheels over that too.
I was.
So
Well, first I'm like, why did she say it was 7051? And then I read it. I'm like, oh.
Hallelujah.
Apparently
He
they're going
said-
to the Amazon
he
cart
said
today.
yesterday-
This may not be more.
Why?
Because I just got the link for the. And then I
Oh,
said,
my
Okay.
God. Okay.
Hopefully she doesn't start it till.
Well, we don't have a second meeting in February, right?
Good morning. How are you?
Good, how are you? Good to see you. City attorney, or county attorney in the flesh.
Well, you know, I had to be in the
Special
building.
hearing, okay.
I
Okay.
didn't know you needed me.
Always. Let's see. Okay. Good morning, how are you? Is this one gonna be on YouTube
Yes,
as
sir.
well? Okay. All right, are y'all ready?
Yes, sir.
Right. Good morning, everyone. The time is 8:34. I apologize for being a few minutes late. I hereby call this special Citrus County Code compliance hearing to order. We follow an agenda at these hearings. The first item is the call to order, and the second is the pledge of the flag. So I'd like to ask you to join me in the pledge. I pledge allegiance to the flag of the United States of America and and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Good morning.
Morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
Thank you. So today we're here not for the usual list of hearings. This was specially set, and I issued an order regarding this hearing a few weeks ago that included a request for briefing. I did receive the brief from the county, and I reviewed it. So I am ready to proceed unless there's any preliminary matters that y'all want to take up. Okay.
I believe the respondent also filed
I did not get a copy of respondent's brief, but
I actually emailed it prior to the county emailing theirs.
I did not get it. And I usually check my junk folder as well, but I can read it on the fly. Do y'all have a paper copy or anything?
I
Or?
don't have a paper
it.
Okay.
I can
No, that's okay. If it's forwarded to me again, I can.
I didn't email it directly to you.
I understand.
Have your email, but
Let me see.
I think the issue might have been, sir, that I noticed that Lori wasn't on it. No, Jillian was on it instead of Lori. I'm not quite sure why that happened. Unfortunately, Miss Antrim was out sick yesterday. In fact, I'm very surprised that she's here this morning. Kim and I were gonna try to fill in for her because she wasn't. So I noticed that Jillian had been copied and not Lori, but I wasn't sure why that was.
I never saw it.
Well, I have access to my email, so if
Somebody can get it to you.
yeah, if it's sent to me,
Kim, can you forward it? Because I'm booting. Sorry.
cwa@wa.legal. If y'all don't mind, I would just take. I mean, I don't know if there's any daylight. Is there any daylight between the briefs on the answers?
There's a couple of issues that we were not consistent with each other on.
Okay.
And so those are gonna have to be resolved too.
Okay, great.
What email address do you want to send it to?
That's cwa@wa.legal.
I'm not sure, Kat, why my computer is not finding internet. I'm speaking to the woman in the room back there.
One behind the camera.
Who's our expert?
Great Wizard of Oz moment right now.
Here she comes. Save the day, I hope. Which one are you trying to get on?
I don't know. It's just.
Law.legal. It says it's sent.
Okay, great.
We have to have our younger person in the room to take care of it.
It's been spinning for a while.
Force quit?
Okay, I've got it.
Thank you, ma'am. She's amazing. She saves us so many times.
All right, so I'm now in receipt of respondent's brief. I'm just going to briefly look at it, if you don't mind.
Who's next? I don't know that. Do you know that for a fact?
Okay, I have two questions for the parties. Swartzel, first of all, if I understand your memo, it's your client's position that even if I found that the delivery of the notice to the statutorily permitted address was, presumptively valid, as it says under the statute, that under the circumstances of this case, I should still find that it was inadequate because the county was in communication with you prior to the hearing.
Yes, because of the due process considerations, the statute is written in a way that is intended to ensure due process, but it also allows, as I said, for
It can
other
be rebutted,
circumstances.
for sure.
And so that's why the case law is all about the specific circumstances. So based on the fact that the county was in communication with the corporation's attorney about this matter just before the notice of hearing was
Oh,
sent.
and it wasn't you? It was the corporation's
Correct.
different counsel?
I'm only appellate counsel,
Okay.
basically, so that was their kind of on-staff attorney that handles these matters. And then also, because it was sent to two different addresses, the notice of violation was sent to a different address than the notice of hearing. So even if the county wanted to make sure to cross its T's and dot its I's by sending the notice to the statutorily required address, it would have been reasonably calculated to ensure that there was notice to reach out to the attorney and make sure that the attorney was aware.
Ms. Antrim, I did read the brief. I think it's the county's position that adequate notice was afforded because it complied with the statute.
Yes, and the attorney never filed a notice of appearance with the county. We don't send the notices out through our office, they're all sent out by code. And it's my understanding they actually sent them to the registered agent's address, which is on the property appraiser's website, as well as to another address, but which came back unclaimed. But that the notices that did go to the address on the property appraiser's website were signed for. The question was whether were they really signed for?
Right, and then we had some credit card records, and we'll talk about some of that stuff.
Yes.
Well, so I just want to make sure I understand everybody's position on this. So it's the county's position that, among other things, you didn't necessarily know that an attorney was going to appear for the purposes of a hearing or that service would be valid because there was no formal appearance made.
Right. I had talked to him several times on the phone, and like I said at the hearing, I was surprised they weren't there. But I did not know at that time that he had not been given notice. And when I checked, I found out that Lori did not know that he was representing them.
I see. Does the county get charged with knowledge? That's an interesting question.
Well, and I think the issue is obviously, it's difficult when, in this instance right now, the county means Ms. Antrim, but
Yes.
really the county is an entity that is sort of responsible, the arms and the
Right.
legs and all of that. So while certainly Ms. Antrim was not the one sending out the notice and all of that, and I understand that. And as soon as Ms. Antrim became aware that
Yeah.
we did not have notice, which was at the time of appeal, she contacted me to bring us back here. So obviously it's not a professional claim
Oh,
against
no,
Ms.
I
Antrim.
agree, yeah.
But certainly, the registered agent address for the corporation is the attorney's address, and that is where the notice of violation went. The notice of hearing did not go there, and that's not something that's been provided, as there's no evidence that it was, and it's my understanding that it was not.
Well, then before we proceed, is it your position that the county failed to follow statutory requirements?
No.
Okay, I just want to make sure. I do understand your argument. I'm not going to rule based on that at this point. I want to get to the meat of why we're actually here, but there was one other issue in the briefs that I wanted to address. The matter of legal responsibility. So in your brief, you address the irreparable harm, and it's your position, I believe, let me know if I'm wrong, that even if we find that a violation occurred, you're raising the point that there's still a question of whether or not your client can be held responsible under the facts, because I think it's your contention that under the code and applicable statutory sections of Chapter 162, that the actual wrongdoer should be held responsible if we know that it was someone separate from your client, correct?
Yes, and I don't believe that Ms. Antrim and I are that far off on this from reading the brief. There's a brief acknowledgement at the beginning of that paragraph in the county's brief that acknowledges that whether something's irreparable or not is not part of the standard or burden of proof. So it's our position that whether or not something's irreparable in harm is relevant for two reasons. One, in the type of fine that can be imposed once there's a finding of violation, which was taken into account. And two, in terms of the county's ability to waive, to sort of fast forward through the notice requirements. So the county can, if there's a danger to the environment or irreparable harm, they can say, we're not going to give you notice of violation, we're not going to give you an opportunity to cure, we're going to immediately go to the special master and ask for a hearing immediately. They didn't do that. They gave a notice, and obviously we have issues with the nature of the notice. They gave an attempt at a notice to cure, which again, or ability to cure, or something like that. Although again, I raise an issue with the reality of that. And then they waited the 30 days. The issue of something being irreparable really only came up once, from my review of the recording of that hearing, once everyone was talking about sanctions. Once there had been fine.
Well, that's why I care about it. I mean, to be clear, so, one of the questions that I've been concerned with is it really irreparable if a tree is cut down and they could just put another oak there or something like that? I think the county's brief does a pretty good job at addressing it and giving the precedent for why it's probably appropriate for a one-time fine. At least it's legally acceptable under precedent. That's why I've been concerned with it.
And that's why I really didn't address that piece of it
Yeah.
too much, because I don't necessarily dispute that, and I just don't think that the logical reasoning reaches that point.
Okay.
Because of all of the other issues.
But I want to address the who is legally responsible thing. So, I mean,
Yes.
you raised the point last hearing that Ms. Antrim mentioned in the original hearing that the county had an idea of who was responsible, and it didn't sound like it was your client.
Yes, and the code inspector brought up that they had conversations that from their knowledge that the owner of the property was not aware
Right.
of this as well.
So is that relevant for this hearing?
Yes.
And I mean, I think you say so in your brief, so I want to clarify for the record and my own understanding that even if all these other issues go away, in other words, that I affirm or don't disturb prior findings regarding notice, you're still going to ask, I believe you're still going to ask me to find that your client's not responsible because the evidence, or the county doesn't even believe that they're legally responsible. Is that right?
Yes, I don't dispute what was cited the last time we were here and in the original hearing from my review of the record, that there is a presumption that the property owner is aware of or responsible for that. I think that makes sense. There are practical reasons to have that in the law. However, that same exact section of the it's the Land Development Code specifically that was cited for that. This subsection A is what says that there's a presumption that the property owner is responsible. Subsection B, and that's in 1800, says that it's a rebuttable presumption. So I think that, yes, I do believe that the record was clear enough that was rebutted. However, if not, that was part of why we wanted to reopen the evidence.
But I think you're saying it's rebutted under the county's own
Correct.
evidence. Okay. Ms. Antrim, what do you say to that? I mean, that's something that, just based on the record, my recollection, my review, concerns me a little bit. I mean,
Well, property owners are often responsible for what happens on their property, whether or not they in fact caused it.
Yes.
I mean, all the tort cases are on that. I also have a case, this has to do with the mobile home park, where the mobile home itself was the problem, but the park was the landowner, so they were the ones that were considered the owner and sided with the code violation, because code violations run with the land.
Yeah, and I mean,
subsequent purchasers are held responsible for bringing their property up to code, so whether or not they caused it.
right, and we have all kinds of cases here where, people who own undeveloped land, someone dumps something on their property, they need to clear it. They're
Or
the
we have
victims.
squatters.
They're the victims, but they have to clear it. I get that, but I guess those are cases where evidence isn't normally presented to me from the county itself that the owner didn't do the wrongdoing. And is it your position that under the Citrus County Code, even if you, and I'm not saying this is your position, but even if you agreed that respondent wasn't responsible for the violation, that I can assess a fine against them?
Yes,
Okay.
yes. And they can take action themselves against the
Mhm.
wrongdoer if necessary.
Mhm.
But there would be no purpose then to clarify the land development code itself from Citrus County. I mean, forget case law, forget interpretations of whether or not it's permissible for counties to choose to have these sort of strict liability ordinances. The land development code says the presumption established by this section shall be rebuttable as part of the enforcement proceeding. So,
Well, now, which section specifically
so
are
this
you
is in the
referring to?
land development code,
Mhm.
1800, section 1800B.
Okay,
I
18.
pulled that because that's the same section that establishes the presumption upon which the county relies.
All right, let me just take a look at it real quick. I want to get these legality issues framed and out of the way before we go into evidence, because that'll help me understand what we actually need to get evidence on. All right, 1800B?
Yes.
Okay. So, Ms. Antrim, do you have the code section in front of you? Let me know when you've reviewed it and are ready to talk about it. The way I read this is that this is the reason why we are able to find violations on the kinds of cases that I just discussed. It's presumed that they have knowledge, and therefore they're liable. And as we've discussed before, it includes owners, tenants, occupants of land, and it then becomes relevant. We can take evidence on it, but I think this probably is an issue for the hearing then, as to whether or not the presumption is rebutted.
I think this is separate than a code action.
Okay, so it's just the LDC versus.
Yes.
I see.
Because-
Sorry.
Go ahead.
Well, the LDC refers back to section 19 of the ordinances. So it specifically states in the land development code that enforcement actions related to the code will go back to section 19 of ordinance. So they are connected. The way I found this was because I was searching for for whatever authority the county was using to claim that there was presumed knowledge, and this is the only place I can find it in Citrus County law.
And where does it specifically refer? You mentioned
It says in, let's see, I'm in 1200F,
Mhm.
Enforcement of development orders and the provisions of this LDC should be through procedures that are efficient, effective, and consistent with code enforcement procedures established by state law. The violations my client was charged with are in the LDC, they're under LDC.
All right, let me get there. You'd think I have the whole thing memorized, but there's a lot of pages.
There is something to be said for the electronic versions where I can control F.
Yeah. Okay.
1200 is like the first page of chapter 1.
Yeah, I'm trying to, there we go. And I'm sorry, Ms. Wurtzel, where did you just read from?
1200 F.
F, okay. Enforcement of development orders and the provisions of this LDC should be through procedures that are efficient, effective, and consistent with code enforcement procedures established by state law. So I think what that's saying is the LDC should be consistent with Chapter 162.
To be clear, the reason we're starting in land development code is because according to the notice of violation and the order, the final order finding violation, are finding my client violation under land development code, 4002 subsections A, B, and C. So that's why land development code is relevant. I'm not sure why land development code and the provisions within it would not be relevant to.
It would. I mean, if 4002 is at issue, then 1800 is at issue. Okay, so I think that presumption is probably an issue for the hearing, and as well as the notice. So I think those two things are at issue, and I'll want to take evidence on those issues, unless there's a county has a different position. All right, I'm not hearing any, so I think I'm ready. This is your hearing, I think, so I welcome the presentation of whatever you've got.
And I believe we were going to consider everything else that's already been provided as
That's
evidence.
exactly right.
So code enforcement doesn't need to present its case.
No, I've reincorporated the evidentiary record, although I do have a question, I mean, let's see, let me just check my, is there anyone from the public who's going to want to be heard in this case? Okay, I see in here none, I just want to get that out of the way. I mean, Mr. Norman, have you been sworn in?
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
So, good morning.
Good morning.
I guess I'm just kind of taking the lead on this because I know what I want to know and what I don't. Do you remember the hearing and your testimony in the prior hearing?
I do.
Okay. And do you recall there being a concern about who is responsible for the violation?
I do remember there being a conversation being held after a notice was issued, and I do remember there being a claim that there was, they weren't aware of the development happening. But I also know that with other cases as well, just because someone says they're not aware of something happening doesn't necessarily mean that's
Well, that
not
may be true, but do you have any reason to believe that it wasn't the respondent in this case who's responsible for the violation?
The only thing I have
Based
is,
on hearsay or otherwise?
the only thing I have is based off the conversation with them.
Can you tell me about that conversation?
I mean, that was conducted, I believe, via email, where they responded and saying that they weren't aware of the.
Okay, so it wasn't oral.
Not that I spoke with anyone
Okay.
directly, no.
Okay. So other than that, you have no other evidence or reason to believe that it was not the respondent?
Based on my inspection of the properties and even the interactions of the people that I've had out there, no one's taken claim of doing so out there. I know that I have had conversation with folks out there before who were actively working on other sites. They didn't claim any responsibility as far as the parcels in question today, though.
For some reason, in my mind, I have some recollection, so I'm hoping you can disabuse it or clarify it. I have some recollection that there was, well, let me ask you this. Are you aware of anyone who's going out there and just clearing sites or cutting down trees in that area?
I mean, we are aware of that taking place on other parcels, but for these two, I'm not sure.
Are those, the parcels that you are aware of it, are they nearby and or contiguous to these two parcels?
Everything out there is in close relation to each
Okay.
other.
So is that a yes?
I would have to say yes, yeah.
Do you have any concerns that whatever party, well, tell me about your concern. I mean, I need to understand the context here, because I thought the county was concerned about this, that it was not the respondent and that it was some other party that might be responsible.
No, I just included that in my testimony, that that's what they had informed to us.
Okay.
That's just, when we're asked what kind of interaction we had, that was the interaction that I had
Yeah,
with
that's
the
fair.
attorney. I'd never spoken to the actual owner.
Mhm.
That was just the information that was provided to us from the attorney at the time.
Have you been given any names or identities of the parties who may be responsible besides the respondent?
It would all just be an opinion. There's nothing factual.
I don't want
that-
opinion, I guess. I
Yeah,
guess
there's nothing factual that would lead me to believe who could actually be doing the clearing firsthand.
Well, my question was yes or no. So the question is, have you been given the names of any persons besides respondent who might be responsible for the violation in this case?
No.
Okay, that's fine. Well, those are all the only questions I had for you then, and I appreciate that. Do you have a cross-examination?
Just something, I did have, I don't know how much, I know the rules of evidence don't apply here, so in terms of the formality, I do have exhibits. They were actually attached to my memo of law.
Okay.
But I believe one of them is just a set of emails with the prior attorney, and I'm not sure if that's what the code enforcement officer is referring to. He's not on the emails, but he may have seen them. So to the degree I needed to authenticate
You
anything.
have the right to cross-examine.
I don't know, are these the emails that you saw that you're referring to?
Ms. Antrim, do you want to look at these before?
They're the ones that were attached to everything.
I think I've seen them
Okay.
before.
Here's the question, Mr. Norman. Have you seen these emails before?
Vaguely familiar.
Did
Just
you-
in speaking with Lori.
Okay, no, I need to clarify this. So,
I was just reading over them to see.
do you
I
know
remember
if
them.
you've seen those emails before?
I know I've seen some emails. I'm just not sure which of these I've seen.
Okay, but no, when you mention in discussing with Lori, I think you're not referring to Lori Wurtzel, you're referring to Lori Spiros, correct?
Lori Spiros, yeah, I apologize.
And in addition, is it that Ms. Spiros showed you the emails? Is that why?
Yes.
Okay, all right.
I don't have any questions.
Okay. Thank you, Ms. Norman. Unless you're called back, I appreciate you being here. I welcome your presentation, yeah.
Can you say your name?
Walter Medlin.
Sir,
Oh,
do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
yes, ma'am.
Thank you.
Thank you.
And Mr. Medlin, how are you associated with Royal Silverstone?
I'm the owner.
Okay, you're the owner of Royal Silverstone?
Yes.
And then does that mean you're the owner of these properties that we're here about today?
Yes, I think so.
Okay. And when's the last time that you visited these properties?
Can I ask you a question first? Do you have a copy of when I bought them? It's probably 30 years ago, 40 years ago.
Okay, so that estimate does the trick, so.
Okay, all right,
More
okay.
than 10 years ago.
Oh, yes, yeah.
Okay.
I don't think I've been to Inverness in 10 years.
Okay.
Well, then you're
And-
missing out, sir, because
I had a problem getting here even with Google.
20 years ago, there was a Fina station and some turtles, and now there's a lot going on, so.
Oh, it's a whole different world here, man. It's, It's good to see. I come from Kissimmee. I watched it happen over there for
That's right.
years and years and years, so.
Do you have employees in your business?
I have several businesses and
In
some
Royal
of,
Silverstone?
no,
Okay. So to your knowledge, has anyone associated with you or Royal Silverstone visited those properties in the last 10 years?
yes,
Okay, for what purpose?
for the purpose of looking at what the problem was. And a guy that used to work in another business for us moved over here. My son reached out to him and asked him if he could take a look and see what was going on and maybe try to find someone to clean it up.
Okay, and so you're referring to once you guys became aware of the violations?
Yes,
And are you referring to the one that was already resolved and dismissed?
I'm not sure, but,
To clean something
Okay.
up, right?
Okay.
Prior to that, prior to finding out about these violations pending, had you sent anyone to that property?
no,
Okay. To your knowledge, has anyone associated with you or Royal Silverstone visited those properties prior to learning about these hearings?
not to my knowledge.
You're aware that the county has a signature that says you signed for mail
Mhm,
in
yes.
Florida on May 22nd of 2023.
Yes,
Did you sign for that?
no.
How do you know?
I was in Indianapolis at the time.
Okay, and what period of time were you in Indianapolis?
I'm not sure my son figured it out and you, and you told me, so.
Okay.
I'm bad about dates and I'm up there about 5 times a year or so.
Did you use your credit card records to
Yes.
help you?
Yep, my son did.
Are those your credit card records?
They look like it. Yeah, they've got my name on it and that's my card.
And these are from that period of time?
I think so.
So you were able to review those to determine that you were in Indianapolis during the month of May?
Yes,
Do you own a home in Indianapolis?
yes.
And is that why you were there?
Well, I have businesses there too, so.
Okay. Do you have any idea why the post office would say you signed for something?
Over the years, I've gotten a lot of certified mail, and usually what happens, I'm out of town a lot, and after I think 4 days, if you don't pick it up, they send it back. But I've never had a situation like this where it was sent back with a signature on it. And
When did you find out about the hearing that was in the notice?
when Mr. Friedman called me that he had gotten notice of the violation, I believe that was the first time.
Okay, so who's Mr. Friedman?
He was the attorney that has represented me for a lot of years and was I think you refreshed my memory that he's a registered agent on the corporation. Okay,
And so he told you he received a notice of violation?
yes.
Okay. And do you recognize these emails?
No.
What, do you see who that's from?
Yeah, Marty Friedman, yes.
Is that your attorney?
Yes.
And you're CC'd on those emails?
And what?
Are you-
Yes,
You're
right.
copied on those? Okay.
Mhm.
And those are about the violations, right?
I assume so.
Okay. And so, did you know that there was a hearing that your business did not attend about these violations
Afterwards.
afterwards? And how did you find out afterwards? Do you know?
I think my son told me because once this began to take place, he dealt with Mr. Friedman and usually between the two of them, they handled everything, so.
Okay. And did Mr. Friedman, he didn't attend the hearing. Would he have been the one that would have attended the hearing?
And probably with my son, probably.
Okay. So if you would have known about the hearing and your son would have known, would you have sent them to the hearing to deal with it?
Well, like I'm here today, they probably said, get your butt over there. So, anyway,
Okay. And once you became aware that you had missed the hearing, did you speak to lawyers about that?
my son did.
Right.
I asked him I'm not sure how we found you. Yeah, I'm not sure. I called about 10 law firms here in the county, and I'm trying to think of the guy that I called first.
Well, you're well represented,
Well, so
so
when there's
that's,
a problem, you take care of it is the
Yeah.
point, right? Or
Yeah,
you can find
well,
someone who can.
they usually,
Okay. And do you know anything about the trees cleared on this property?
about the what,
The trees that were cleared on this property?
other than what I've heard through the attorney and my son.
Okay. Do do you have any idea who did that?
No,
Did you do that?
no,
Did anyone you know of do that?
no,
Okay.
or not to my knowledge.
Okay, or anything that, clear any dirt, or do anything on the property at all?
Nothing.
I have no other questions. Stay there.
Sit down.
No, stay there for a second in case the county has any questions.
Sandra, do you have any cross-examination? Or,
Just a few questions. Do you pay the taxes on this property?
Yes,
And do you consider yourself responsible for what goes on this property?
no,
No, never?
no, I'm not here yeah, no, I don't, I didn't do it. I didn't do it. I didn't ask anybody to do it. I didn't know anybody was doing it. Maybe we ought to clarify the word responsible. I am the owner, and I guess that puts some responsibility on me.
Do you think you have a responsibility for paying attention to what's going on with your properties?
No, I think that would be up to me, and I would suffer the consequences, which is why we're here today if I don't pay attention. If I don't pay attention, sorry, my throat's dry.
I'm in the same boat you are.
Yeah.
And do you,
I ate it, go tic-tac.
do you feel that you have an obligation to secure your property?
No,
No?
no.
Thank you.
I don't have any questions, so,
Now you can sit down.
yeah, thank you for your testimony.
I do have two
Are you
exhibits.
I was gonna say, are you gonna move that email exchange into evidence?
Yes, I intend to, Your Honor. Or the only thing is that I realized I printed these from the petition for writ of certiorari, and they had exhibit stickers on them, on the bottom. But
Well, if we don't pay attention to the fact that evidence is hearsay, we probably won't pay attention to the existence of exhibit stickers, but
They're just the same things that were with the petition for cert.
Yes, exactly. Just making them part of the record. Should I approach with these?
yeah, absolutely. It's two sets.
They're quite literally marked as G and D, but
And so it's your representation that the credit card statements are, I guess we didn't really discuss these during the testimony, but based on the dates and the name on them, this is being offered as evidence to corroborate the fact that Mr. Medlin, the only person responsible for the company, was actually in Indianapolis at the time.
correct, it's just corroboration.
At the
his
time of
testimony.
what?
At the time that the notice was received, signed for, which is May 22nd.
Do we want Mr. Medlin to authenticate those?
He did say that he recognized them. I had him say he recognized them and he used them to determine where he was, but I can ask him.
Let me look through these. I may have questions.
There's two different statement periods accounted for there, and one of them, it's at the very end, I think is May 19th or 20th.
I see the
So-
20th through June. Page 3 of the statement period from May 22nd through June 21st shows the dates in question. Mostly charges in Indianapolis from May 21st through June 1st. I would like, if you don't mind, I would like to ask Mr. Medlin some questions about these statements. Mr. Medlin, can you hear me okay? Okay.
No.
No? No?
But I'm trying
Well,
hard.
let me get into the microphone then. Have you reviewed these credit card statements that have been produced to me today?
No, not really.
Okay. Let me ask you, how often do you go back and forth between Indianapolis and Florida?
Probably 5, sometimes 6 times a year.
Okay. Where do you primarily reside?
I'm sorry?
Where do you primarily reside?
Kissimmee,
In Kissimmee?
Kissimmee,
Okay.
Florida, yes.
Do you drive from Indianapolis to
Well,
Kissimmee?
for years I flew, and then when COVID came along, I didn't want to fly, and so I didn't go. And then when COVID eased up a little bit, I started driving, and I love to drive.
Yeah.
I'm stupid enough at my age, and I confess, I get in the car at 4 o'clock in the morning and drive straight through and get in there about 8 o'clock at night.
Nice.
Which is crazy, so. But,
Yeah, yeah.
But I enjoy it, so I still enjoy driving.
I do too. I call it windshield time. So I notice on the statement that there is a stop on June 2nd at Ford of Dalton in Dalton, Georgia. Do you know what that was about? Why would you have stopped at Ford of Dalton in Dalton, Georgia?
What was the first word that you said in that?
Ford, F-O-R-D.
Oh, there could be two reasons. It could be a service station there at that exit, but then I'm not sure which trip it was. The transmission went out in my car, and it was towed to the, oh, you said Ford of Dawson.
Ford of Dalton.
Okay, Ford of Dalton, okay, all right. I'm sorry. No, the transmission went out in the car. I called 911 or whatever they call them, Champ up there, I think. He carried me down to a service station. I got a tow truck. They took me to Ford of Dalton. They got me back on the road, and I finished driving home.
And there is a charge for an auto repair of $68. There's a charge at Ford for $300. So that seems to square and be consistent.
Yes.
The reason why I'm asking is because I'm trying to establish that these are your statements and these are your charges. Okay, so
Okay.
This was on a MasterCard Black card.
Right.
Is this the card that you use on a daily basis for your charges?
Yes, I have it on me now if you care to see it, so.
I don't. I think that satisfies my inquiry regarding the cards. Unless the county has a substantive objection, I'm going to admit the emails as exhibit. I don't know where we're at. Ms. Spiros, do you know what our exhibit count is in this case?
It would be,
D? E?
D.
Okay, then the emails will be exhibit. Oh, yeah, please, Mr. Medlin, thank you. The emails will be exhibit D, the credit cards will be exhibit E. Let me take a look at the emails. Are the properties still in violation on these two cases? I know one abated.
Well, the problem is that there was no curative action proposed.
I see.
So the one that did have curative action proposed was
You were able to
remedied
take care
and
of it?
dismissed.
Okay, that makes sense. Do you wish to make any argument or statements?
Simply, I mean, I would like to piggyback off of that particular question, which is whether or not the properties were brought into compliance. The idea, and Ms. Antrim and I had this conversation at some point, and that's reflected in the emails as well of the original attorney, is what can we do to fix this? It's really not the property owner's position that I didn't do it, I don't know about it, so I don't have to fix it. In fact, that's the opposite. From the very beginning of receiving the notice of violation, the question was, how can I fix it? And there was no answer. Essentially, you're responsible for it. It is what it is. Once my client did become aware of a curative action that was possible on one of the cases, they did do that, took care of it, and did not worry about the fact that they had to expend money that they shouldn't have had to or was unfair or whatever. When it comes to what it appears the county claims is an irreparable damage of some kind, if a property owner didn't do it, then they can't cure it. And so as just a public policy issue, it seems to be holding someone responsible when I think that the purpose generally of code compliance is compliance.
Mm-hmm.
And perhaps there's some sort of deterrent effect, but that doesn't have a whole lot of use when.
Well, that's why the presumption of knowledge exists, right? But I think what I want to ask you is this. If let's set aside the irreparable issue just for a moment and the legal responsibility issue for a moment. Let's say that I agreed with you that your client did not have notice based on the evidence that's been produced today. How does that change this case?
Well, I think like any legal argument, it's tiered, right? So from my position, we could come in at any point in those tiers, and I have arguments that could get us
Well,
to the
so
end.
we're early. That's why I want to go notice
Right.
first. If I agree with you that notice isn't there, what are the consequences?
Well, honestly, I think that we are currently experiencing the remedy to that. I think that that issue was raised at the appellate level, which is at that time the only way we could raise that. And I think that had the appellate court reached that issue and weighed in our favor, the appellate court could have remanded it back to this tribunal.
But I guess where I'm going with that is even if I agree with you about notice, they're going to come back with the same evidence and the same stuff, and there's sites that have been cleared. So does notice matter for the purposes of this hearing? Because even if you win, you're still having to deal with the other stuff. Am I wrong?
No, I agree with that. I think that at the last hearing, there was an issue of whether or not we had, it was hearsay or whether or not, we were just trying to get to the point of reopening the evidence, I think. And so I would agree that.
Okay. So I don't need to, I can kind of deal with that however I deal with it, but ultimately, regardless of what I hold, we still have to deal with the ultimate issues.
But kind of, and to clarify,
Okay.
there are two due process and two notice issues. One is the one we dealt with in terms of notice at the hearing, which I would agree has been remedied by this proceeding. The other was the notice of the violation itself and the opportunity to cure. That is where I do believe the irreparable idea does come into play earlier in these tiers, is that the code, and I cite all of that in my memo, but the code does require notice, and so does the statute in section 162, notice and a reasonable opportunity to cure. The county can get around that by saying it's irreparable and therefore they don't have to offer that, but they did. They offered an opportunity to cure. They gave a notice of violation.
But let's say that was a mistake. Let's say that they didn't need to say let's say that you're right about that, all they have to do to get around it is say that it's irreparable. Why does it matter that they then said you have an opportunity to cure? How is anyone prejudiced by that if it's a mistake?
It was simply that they didn't offer an opportunity to cure, and that's required statutorily unless they've proved
Unless
something
it's
different.
irreparable.
Unless they prove something different.
Okay.
And in that circumstance, that's their burden. But and I agree that's earlier up in the tier, and I do think that probably the most significant arguments from my perspective are lower in this tier. But I don't want to waive those arguments.
I respect the argument, but that is one I think I can rule on. I do think that I was persuaded by the county's brief on the nature of the irreparable remedy and the case law supporting that. Not remedy, the irreparable finding. I think based on the facts, that is something that's able to be sustained. I don't think there's prejudice whether the county inadvertently or mistakenly or otherwise mentioned an opportunity to cure even though it was irreparable because of the lack of prejudice. And that means under case law that there is not a due process issue. But I think these other issues, I'm wrestling with the other ones that you're bringing up. And so I want to get to those.
Yes. And so those are remaining at whether or not there was legal responsibility. I think with the preponderance of the evidence standard, obviously before I had to argue that the county's record itself and to the degree that it's necessary for decision-making, I would also, I listed in my exhibits to my memorandum the link for the video from the hearing because I do interpret some of those statements a little bit differently than what was portrayed today in terms of...
I do too. I was surprised.
However, we've supplemented the record obviously at this point as well. I would submit and argue that to a preponderance of the evidence standard that we've overcome the presumption, which is a rebuttable presumption. There is no evidence at all of my client's responsibility, so the only legal argument the county has is that presumption.
I'd like to turn to the county on this. I'm concerned by the facts here regarding legal liability. I've read Section 1800, I do think it applies to violations of Section 4002. I don't see any evidence in the record of knowledge on the part of the owner. I find that the witness was credible and spoke, fluidly and credibly about the credit card statements, and it seemed credible about the other testimony regarding knowledge on the property, and there's nothing else in absence. And I just want to tell you what I'm thinking before I get to the good part. When we have a violation where someone has overgrown grass over 18 inches or junk, nuisance, debris, that kind of thing, the code obligates me to provide a time to comply. And regardless of whether or not someone put the junk there or not, they have an opportunity to avoid the fine by taking care of and securing the property. In this case, it's conceivable that not even just on this property, but on a lot of properties, someone might go around dumping stuff. I find it a little bit harder to believe that someone would just go around clearing stuff, but I'm curious, doesn't 1800 apply, and haven't they overcome the presumption?
Well, whether they've overcome the presumption is a question of fact for your determination.
Okay.
However, it would do away with the whole provision in chapter 162 for fining for irreparable or unchangeable, whatever, harm. And you have the provision in the statute that provides for it. If something can't be corrected, then there's a fine. And then we also have the case of Verity versus Metropolitan-Dade County, where they said the county's authority extends to fining for irreparable or uncorrectable violations. It's not just to make somebody comply with the code.
And I agree, and I'm already finding in the county's favor on that point. I think that based on these cases, absolutely I was persuaded by your brief on the subject. What I'm concerned about is that 1800 says what it says, and if in a case like this, someone gets up and says, this is a concern, I think, for the county as well. Evidence regarding knowledge. It's very rare that we have cases where people say that they don't know, or, in fact, most of the cases that I seem to get these days are people standing behind what they've decided to do in violation of the code. But this isn't that case.
We do have a lot of properties where we have absentee landowners.
Yes.
And they claim no knowledge as to what's going on.
I very rarely hear those cases here. I don't know if it's because y'all don't bring them or otherwise, but unless I see another reason, I think that under Section 1800, they've proven that the owner doesn't have knowledge and therefore shouldn't be liable. I'm looking to understand the county's position as to a reason why that shouldn't carry the day in this case.
Well, it's a question of fact for your determination.
I know.
And the reason I would argue it shouldn't carry the day is because that would mean any absentee landowner, which there are plenty in Citrus County, could always claim, I had no knowledge, therefore you can't fine me or do anything else, basically. Because this would go to not just fines, this would also go to orders to correct.
Orders to correct. So, can you explain that?
Somebody could come in and say, I had no knowledge that that was going on my property, so I'm not responsible.
Yes.
And I don't have to correct it, because somebody else did it.
If it's a violation of the LDC
Yes.
or otherwise.
Yes.
I think that is a logical consequence if I believe the property owner.
Do you have a copy of the Citrus County Code with you?
I think I do. I think I have a
Chapter
copy of.
Chapter 19?
Yep, I have 19. Is there a particular, do you want to see it, or?
No, I have it. I'm just looking at the definitions.
Okay, definitions.
Of who a violator is.
All right. Violator shall mean the person creating or permitting the violation of any provision of the county codes or person who owns, controls, or is otherwise responsible for the real property upon which the violation occurred. And I agree. I mean, I think that that's why the vast majority of these cases end up in the county's favor, because I do think that's consistent with 1800. I'm sorry, am I saying the right code section?
Yes.
Yes.
Okay, 1800, because that enables me to find that, the person who's in control of the property, it enables the county to go after the people who are actually responsible as well. But if the county knows who it is. And in the absence of evidence otherwise, the presumption of knowledge means that this enables me to find property owners responsible, even when they don't show up. But here we have a case where the owner's here, he gave credible testimony, 1800 is at issue. I accept the county's point that if someone's watching this and an unscrupulous property owner, they may be able to create a factual issue for the purposes of the hearing. But I think there's a fairly... Well, let me think about this for a second. How much of the property was cleared? Mr. Norman, do you know that? I don't have the pictures in front of me, so I don't...
Do you need them to get you the pictures?
I'm okay, thank you. Was the entire site cleared?
So for the purpose of the modification of the parcels, when it comes to case number 5826, the evidence that I submitted was in regard to the actual grading of the property. There was actual visible grading. We did have testimony about the stormwater concerns from the grading. In case 5831, when the property was cleared, I have a photo of the exhibit. It unfortunately doesn't have the parcel size. We could look it up on the property appraiser real quick. But it's essentially an aerial image of what trees were there before and what trees remained after, if you'd like to see those.
I guess something that is an issue for determining credibility in a case like this, and I'm trying to assess the consequences for the county going forward if I ruled in their favor, is what are the motivations for a third party to come in onto someone else's property and clear it? I don't know. That seems kind of like a stretch to me. Now that I'm thinking about it, like what would be the motivation for a third party to come on and grade or clear a property?
Well, again, from what I remember from the review of the prior hearing, there were other properties owned by people other than my client whose cases were up for hearing that
Right.
day where the same thing had happened.
That's what I recall
So
too, and that's why I'm
presumably-
surprised there's not more testimony on this. But I guess what I'm trying to understand is I still, regardless of if the county is aware of this being a problem in that neighborhood, whether they'll testify to it or not, what is the motivation of that third party? I don't know. It seems odd to me.
Again, my understanding is that because these properties have no fences or sort of lines that a person would not necessarily know just by looking at it where one property ends and another begins. What I recall from the hearing was that there are developments nearby and that there is a developer who is developing nearby. It could have been something related.
Is this Citrus Springs or is this, it says Inverness.
It's Inverness Village.
Inverness Village, okay.
And again, the unrefuted testimony
I know what the unrefuted testimony
is that my client hasn't even been there in 30 years.
Well, what the county's saying
All I
is,
hear-
look, you do this special master, and every single other 4002 case we have, The owners are gonna be walking into this hearing room and they're gonna be saying, we had no idea.
That's not a legitimate legal argument, respectfully, because
You're the one
sometimes,
who brought up public policy.
yes, and
And
sometimes.
that's a public policy argument.
And sometimes that is relevant when it comes to the interpretation of a vague statute or there's a question of interpretation of law. And when the Supreme Court or any court is determining which way do we go, that can be a consideration. There is no, it's not a vague provision that I'm pointing to in law. The remedy here, unlike when we're talking about arguing to Supreme Court, you have to interpret law this way or else, the remedy here is quite clear. It's not for the interpretation of a tribunal, it's actually for the legislature to change the law, which they can do at any point through their legislative process. This is their law.
Yeah, I'm very skeptical that public policy comes into play even at the highest levels. But I'm not really arguing with you. I'm kind of agonizing on the record and talking about these issues out loud because I want to make a ruling today instead of delaying it like I sometimes do. I do think it's clear under the text of the statutes, but before I make a ruling, I want to make sure that based on the county's concerns, that this doesn't throw a whole block of statutes into chaos. And I'm just thinking it through. The one saving grace is that there's a credibility determination that has to be made. You've presented some evidence on this point. I doubt that most folks would be able to do that. I do agree with Ms. Wurzel's interpretation of how 1800 applies. I do think the presumption of knowledge has been overcome, and so I don't know that I can sustain a fine based on the wrongdoing of another party when knowledge hasn't been established for the owner. When it's not established, or when they generally don't know, I think Section 19, dash 24 and Section 1800 operate to give the special master authority to maintain these kinds of violations. But that's my finding. Let's assume that I keep that finding. Then under case numbers 218-5826 and I don't have the other one.
5831.
5831. I think that would then moot the appeals, correct?
Yes, we're under order to advise the court whether or not the appeal needs to continue.
Ms. Antrim, if I did sustain this finding, what would the county be left with? I mean, would the county be left with having to go after the actual violator if they could find the violator? Does it deprive the county of all remedies in a case like this? I mean, right now it's deterrent effect. You're assessing a fine for some kind of clearing that's happening. But in a case like this that occurs again, what would the county's remedies be? Just to go after a violator if you can find one?
I think that would have to be determined when that case came up, based on the facts of that case. I do have a question, though, about the effect of your determination, because we had a bit of a disagreement, I think, as to what you were here to hear today. And I was just looking at the language of the order to relinquish,
Yeah.
because it didn't go quite so far as the motion. But if you were going to interpret it as going as far as the motion had,
I don't want to do something that disturbs appellate
Well-
authority.
and that was my question, was whether or not they had given enough jurisdiction to actually.
I thought I read your brief as saying that.
It said to consider additional evidence, but the motion had said to consider additional evidence to determine whether there was due process. And I don't know that that takes care of
Right.
the
I see what you're,
appeal.
I see what you're
Or
saying.
resolves the appeal.
I see what you're saying.
Or if further action needs to be taken with the court to get them to.
Well, certainly I agree with the county on due process. So if that's the extent of my jurisdiction, then that's okay. But I do think that from an evidentiary perspective, we had testimony without objection regarding the other stuff, but then if I don't have jurisdiction, I don't know.
If I may, I mean, I disagree with the county's interpretation. First of all, I attached the motion that, all of these were joint unopposed motions, which specifically laid out that we, that we had arguments to make and due process arguments. Frankly, I prepared the orders as well, the judge signed them, so we were all part of that process. There would be no purpose in an appellate court.
I don't think they're trying to sandbag you. I think this is a concern that I've raised about, I don't want to do something that.
Correct, but the appellate court would have no purpose in relinquishing jurisdiction to consider new evidence, only to open the record without any more findings from the tribunal, so that it could be heard by the appellate court.
Well, I don't think that's what she's saying either. I think what she's saying is it talked about due process only, so it's evidentiary matters relating to the due process and notice. And originally, I thought that was the issue that you were raising. And then it's become, I think, another issue. So unless I'm misunderstanding what
Again,
you're
the
saying,
order
it's-
doesn't discuss due process at all. It doesn't even use that
It
term.
just relinquishes jurisdiction?
To consider newly discovered evidence.
Okay.
The purpose was, so again, as I said before, so that if the tribunal wasn't willing to reconsider new evidence,